Hello everyone and welcome. My name is Mitchell Zaddo. I'm the Managing Principal at Sharrock Pittman Legal. Thanks very much for joining us for our webinar today on things you should know when considering a retirement or lifestyle community. Before we get started, we'd like to briefly acknowledge the Wurundjeri people of the Kulin Nation as the traditional owners of the land on which our office is located, and we pay our respects to their elders past, present and emerging, and extend this respect to all First Nations communities throughout Victoria and wherever you might be logging in from. Again, welcome. I know many of you have attended our webinars before, so welcome back. And if it's your first time, then an especially warm welcome to you. We hope these webinars are helpful for you just as a resource in what you do, and it's an opportunity for us to share some of the things that we're seeing in our day-to-day practice on different topics that we think will be of interest. You can catch up with the recordings for our webinars by heading to our website and clicking the link for the resources page. Today's webinar is being recorded and will be available as well soon. So don't worry if there's anything that you miss. You'll be able to catch up and share it with anyone else you think might be interested later on. On the resources page on the website, you'll see all our webinars, including not just on property law, but also commercial law, disputes, employment law, wills and estates, and not-for-profit law. Do have a look there when you've got some time. But as I said, today we're looking at some of the things that we're seeing in the retirement village space at the moment. So I'm joined today by Andre Ong and JY Tay from our team here at Sharrock Pittman. Andre is a principal in the firm and an accredited specialist in property law, accredited by the Law Institute of Victoria. And JY is a lawyer in our property team with a particular interest and focus on retirement village contracts and legal issues. And I know they're both looking forward to sharing with you some of their insights today. But before I begin, I'll just run through a couple of housekeeping items. As I said, we are recording the session, but we are in webinar mode, so no one is on camera, don't worry. And if you do have any questions throughout the session, please feel free to type away in the Q&A box. We'll try to get through some questions as we go, if that's appropriate, but we'll also allow for some time at the end. We're conscious of everybody's time though, so we will try to stick to an hour maximum. If we don't have time to get to your question, don't worry, we will get back to you afterwards. And we'll also share contact details again at the end. And you're very welcome to get in touch with Andre and JY afterwards if you have any queries about your own situation. Speaking of which, we're lawyers, so forgive us for some fine print. Needless to say, we can only give some general guidance in this session. Everybody's situation is a bit different. Every retirement village or lifestyle community is a bit different. So do keep that in mind if you're applying any of this to your own situation. And of course, if any of this is hitting a nerve for you, then feel free to get in touch. And just a final note to say that we are looking at things from a Victorian perspective. So if you are interstate, or looking at things in Queensland or wherever, just keep that in mind and get some advice on any differences that might apply in your jurisdiction. So without further ado, I'll hand over to Andre, who'll start taking us through the content. Thank you, Andre.
Thank you very much, Mitch. Welcome, everyone. So I thought I'd just go through a brief agenda for today. So we're going to look at what are your property options after your family home as you're looking to that transition, downsizing as it were. What options are available out there for you? And then in considering that, what are the tax or other concessions that are available to you so that you can do so in the most, you can make that transition in the most tax effective way possible. If you are receiving a pension or could receive a pension, how is that impacted by any of these choices? And what about stamp duty? As everyone knows, the government always tries to take their cut on the way through. So what about any concessions that are available there? And then we'll run through consideration of each of the available options as we see them in terms of downsizing, down to a unit, townhouse or apartment, granny flat agreements, which effectively are a little bit of a subset of that. And I'll run through that briefly. Then residential parks, retirement villages, and nursing homes if you do need that higher care scenario, and a little bit of Q&A at the end. Hopefully we'll have some time for that. So we'll move forward to each of those options. So I've just thought to set the groundwork, I'll lay out what each of these are, and JY will run through them in a bit more detail and relevant legal points as we get to his section. So downsizing into a unit, townhouse or apartment, basically you would still be owning the land, owning your own property, but within this context of a larger owners corporation or group or setup, whether we're talking about a 2-3 unit sort of development where you're going down into a house of that size or townhouse of that size, or a couple of bedroom apartment in a large city building or coastal building. That's obviously one option that people are taking. As a bit of a subset to that, as I said, with the granny flat agreements, that is effectively an arrangement that you reach with a family member, usually, where you would not necessarily just build a traditional granny flat in the backyard, as people understand it. Sometimes it's a full unit in the back. Sometimes it's also just a component of the house that's been built, extended out to create that living space for you. And in that sort of situation, there are agreements in place and available tax concessions there to consider as well. Residential parks, and these are commonly known as lifestyle communities, but that's also a bit of a brand name that's out there. So we'll stick to the legislation terminology of residential parks. But basically, it's a situation where you are leasing or renting out the land, and you're owning the house that sits on top of it. They're governed in a particular way in Victoria. There's been a very interesting case earlier this year, which has impacted the business models of those residential parks, and therefore the consideration that you might have to give if you're looking to get into one of those. Then a traditional retirement village. So these are independent living villages. You'll have your own apartment or your own unit within the larger village complex. The village itself provides some additional services, often a sense of community and community activities. Those are governed strictly within the Retirement Villages Act. Again, JY will go through that. And then if you need a level of care, then you end up with nursing homes as your choice, where you end up with that 24-hour usually nursing care and available support. In looking through those options, we're really looking at it as two different steps. The first bit of which is you need to raise the money, obviously, for that transition, whether it's a sale of the family home or other assets. It's what's available to you and what concessions you might have in raising that cash for that transition across, and then the considerations in purchasing or acquiring your new home and each of those structures that I've just gone over. So we'll run through onto the next slide. So in selling your family home, you would be entitled to access the main residence CGT exemption. So when you're selling your family home, capital gains tax does not apply to that. And obviously that's a very, very significant concession. For most people, their family home is the largest investment that they've got. So in selling it and transitioning into retirement, obviously it's good that the government is allowing you to do that without taking a big tax cut along the way. But as with everything else, there are a couple of limits and a couple of rules which are important to understand. The first one is a 2-hectare limit for your home, especially if you're living in out of Melbourne. If you're lucky enough to have your home sitting on 2 hectares or more, the CGT exemption will apply only up to a maximum of 2 hectares. The way that rule works is, say, if you happen to live in something that is 10 hectares in size, you can pick any of the 2 hectares, as long as it includes the home or the dwelling in that 2 hectares, for the CGT exemption. So that's important to consider where you've got blocks that are subdivided into multiple titles or can be subdivided into multiple titles, and that the values can vary across the site. For example, if you've got your home sitting near the front, near the main roads, near wherever the value is maximized, you might be looking at how you structure your sale so that you're able to apply the 2-hectare limit across to the most valuable components, and therefore the components of the land that have had the highest gain, to get yourself the best benefit. You've got to be an Australian resident. Again, it's an Australian tax benefit, so government has targeted it that way. Now, the usual rule is that it's not used for income-producing purposes. This is intended to be a tax benefit for your home. However, there is a 6-year rule, and that enables you to access or continue to treat your property as your main residence for CGT purposes, even if you have produced income on it. And by that, the most common way would be renting it out if you happen to be overseas or interstate for a period of time. That is a maximum of 6 years that you can continue to treat that property as your principal place of residence and get that tax exemption in place. Easiest example for that would be if you happen to, say, have to go overseas for a bit, you then, say for 3 years, you've then rented out the home for 3 years whilst you're overseas. It was your principal place of residence beforehand, so that enables you to access this 6-year rule. And then, say at the end of the 3 years, you decide to sell that house and you're still wanting to just continue to reside overseas or interstate, you can still treat that house as your principal place of residence when you sell it. You don't have to worry about capital gains across that 3-year period when you were renting it out. There are variations to the rule. The 6 years don't have to be continuous. The 6 years can, in fact, be considered in multiple tranches if there's been breaks of possession through your whole period of ownership. So there's a lot of flexibility there for that 6-year rule to apply. And the other thing to consider is that if in the period of your absence, there is not any income producing use of that property, you can actually continue to treat it as your principal place of residence indefinitely. There are a few hiccups with that sort of thing, especially in Victoria because of vacant residential land tax. So pluses and minuses there, and a few things to weigh up if you're considering this particular, accessing this particular exemption. Now, if you're raising the money for your new home through selling investments, your investment property, as with any other investments, capital gains tax will apply in that sort of scenario. So you've just got to be aware of that. So moving forward from there, I thought I'd run through the downsizing contribution, which is a concession that the government has provided for to allow, and it's a once-only concession, but to allow a additional contribution into super by someone who is downsizing. Now that is capped at $300,000 as an individual, or if you're a couple selling your family home and downsizing, then that can go up to $600,000, and that is separate from any concessional or non-concessional caps. And in fact, as I've got as a dot point a little bit lower down, it's even separate from the limitation if you're 75 or over, where you can't any longer contribute into super. This actually will still apply to be able to get that money in. Now, the practical ins and outs of why you might want to do that is that obviously superannuation is a concessional tax environment. You're only getting taxed at 15% basically, for anything under 3 million. So you're getting a concessional tax rate applied for your investments in super, and you can draw that out in pension phase whilst it's still in that tax concessional environment. So getting some additional money in there obviously gives you a lot better net outcome in the end if you can get it there. Now, that's why you would consider it. Now, what are the eligibility criteria for you to consider? From 1 January 2023, you can now access this if you're 55 years or older at the point that you complete the sale. So if you happen to be 54, you will have to wait until you're 55. And in order to access the downsizing contribution, say if you're a couple, if one of you was over 55 and the other one was under 55, only the person that is over 55 can access the concessional right to make that contribution. So you've got to be careful about dates here and to make sure you line up everything on your sale process so that you are 55 at the relevant point in time, at the point that you sell. It's normally calculated from the settlement date. There are ways to get delays in how different tests are applied, but none of those delays relate to your actual age at the relevant point in time. A few of the other timeframes here, the ATO does give a little bit of a flexibility in terms of asking for additional time for things, but the age limit is not one of those. So you've just got to be careful to make sure you're accessing this or you're intending to access this concession when you are at the right age. So in addition to that, the home that you're selling, you and your spouse have to have owned it for 10 or more years, calculated from that settlement date when you first purchased it. You don't have to have treated it as your main residence the whole way through, but it does have to be able to access the main residence CGT concessions. So I'm flagging here that 6-year rule I mentioned earlier. So you might have owned it for the 10 years or more. Maybe you've leased it for a period of time, come back, and so on and so forth. But as long as you can access that main residence CGT exemption at the point that you're selling, either in whole or in part. So again, for properties that are, say, more than that 2 hectares, you're only getting the CGT exemption as it relates to the 2 hectares. You will still be able to access this because part of your property you were still able to access that main residence CGT exemption. Your home does have to be a home. It is not able to be a caravan or a houseboat or anything creative like that. This downsizing contribution is specific to the sale of your main home, and it's a once only contribution, so you can't downsize multiple times and keep accessing this ability to contribute into super. The time frame where there is a little bit of flexibility is the 90 days. So usually you need to make this contribution into super within 90 days of the settlement date of your sale. The ATO does have discretion to make that 90 days longer if there is a good reason to do so. And one of the good reasons to do so might be to do with your timing and structuring of the acquisition of your new home. So, for example, if you are looking to buy into an off-the-plan unit or an off-the-plan retirement village, apartment, for example, if there is a delay in the completion of that or the settlement of that pushes out beyond the 90 days, it's outside of your control. The ATO does have the right and power to be able to grant an extension of the 90 days to still enable you to access this downsizing contribution, because obviously you're going to want to make sure that you have enough money in place by the time that purchase settlement comes around, but you do need to apply for that extension of time. So if you're aware after the settlement of the sale of your property that there is going to be delay, the prudent thing to do is to make the application for that delay right to be decided by the ATO at that point, as early as possible, just to let the bureaucracy do its thing. Now, be aware, even though the maximum contribution caps are 300,000 for an individual, 600,000 for a couple, that contribution amount can't actually exceed the proceeds of sale of your home. Now, the payments can actually be made from other assets. So, for example, if you've had to apply the direct cash that you've taken in on the sale for a purchase, but you're able to access this, you can still make a contribution raising the actual cash from selling other assets, being aware of CGT if you're selling those other assets, as long as it's still within the amount of the proceeds of sale of your home. So you don't have to exactly time things so that dollar for dollar things are tracking through. If you intend to invest your proceeds of sale and then you're making this contribution from other monies, that's not going to count against you. It's also possible to do a part sale, a part equity contribution if you're only selling a part of a home, but just be aware that, again, it's a once only contribution. So you've got to be careful of that side of things. Now, if you inadvertently break any of these rules or make a contribution in excess of that maximum $300,000 for an individual, those will be treated as part of your usual contribution caps. So you've got to be wary of that because, as you may or may not know, if you exceed your contribution caps, there are significant penalty taxes that will apply to those contributions into super. So again, there's a little bit of forethought and planning that'll have to happen here in order to make sure that you can access that concession properly. Now, how could a pension be impacted by these choices? Now, as you all know, I'm sure, a pension, whether it's age pension or otherwise, is subject to an assets test and an income test. Your principal place of residence is not counted towards your assets test. So whilst it is money that is effectively the value of your home, that isn't going to be counted towards anything when Centrelink is assessing whether you're entitled to the pension or not. However, once you sell it, whether you contribute it into superannuation or if you're investing it otherwise, those just become assets in your own hands. So just be careful about that when you are moving into that downsizing phase. Any of those proceeds of sale that you're investing separately won't retain that exempt status whilst they were your home. There is a little bit of a transition phase here. If you are, selling and then buying something else, there's a 24-month exemption period that would apply as you transition from one to the other. So that again, your pension is protected through that time. Again, it's just a little bit of planning that you've got to have there. Now, from 1 January 2023, that 24 months, which used to be a very strict 24 months, can now be extended out to 36 months, subject to reasonable steps being taken and good reasons as to why there's been that period of delay. But the important thing here with the assets test also is that if you're using that downsizing contribution, your superannuation balances are counted towards your assets test once your fund is in that pension phase. So got to be careful again of where your totals are and how you're dealing with this. And when you're balancing out money that is going across into your new home and money that might be going across into superannuation as you're downsizing, you got to balance out those net impacts. If you're losing some pension because your assets test has gone up by that money going into super, you've just got to balance out those benefits of the additional money in super and invest in that tax concessional environment versus any reduction in pension. Hopefully not a loss of pension, because obviously for a lot of people, it's not exactly the pension payments that are the most valuable, it's the healthcare card and those concessions that go along with that. So those considerations have to be balanced out so you don't cross any limits that you're not intending to. Now, a brief word on granny flat arrangements or agreements. Basically, it's a pathway for someone if what they're doing from in their downsizing plan is, instead of buying a standalone unit or an apartment, they decide to put money in to say their son or daughter's home in order to build a granny flat out the back, small unit out the back. So the legislation in the Centrelink type material does refer to them as granny flat agreements, but in more modern terms, it's just really building your own small home somewhere, whether that's in the back of a backyard sort of property, in the back of your son or daughter's home, or actually extending your son or daughter's home to be able to build that. You want to make sure that that money is still going to be able to be outside of your pension assets test, not subject to the deprivation rules that would usually apply when you gift money, and let alone your own estate planning considerations, because effectively that contribution that you would have made to your son or daughter or someone else's property in order to have that right to live there, you want to be able to preserve your right to that. So what you're allowed to do is have what is effectively a granny flat agreement. That's what they're termed, a granny flat agreement put in place, which establishes that life interest and that right to reside for you. And that way, if that is your plan in terms of investing into someone else's property to give yourself that right retirement living choice for you, that way you can still access the same benefits in terms of having your principal place of residence, or the money that's gone into your principal place of residence, exempted from the pension assets test, and just still be able to access that. Now, moving forward from there, is what about the stamp duty side of things? There are a few exemptions and concessions that are available, but unfortunately the caps on those are probably not the best in terms of what property is worth in Victoria at the moment. So there is an available exemption for a pensioner. So if you're an eligible pensioner and you're buying, say, an apartment up to $600,000 in value, or a townhouse up to $600,000 in value, you actually won't pay any stamp duty. As long as you have that eligibility, you're going to use it as your principal place of residence. Again, this is a once-only type concession, but once you access that, you get that home without duty applying. It is concessional then between 600,000 and 750,000. It's a reasonable concession. It's a few thousand, but obviously the full exemption would be what you would hopefully be targeting to get the best benefit. Now, if you're not able to access that, or you previously accessed the pensioner concession, can't get it again, there is still the usual principal place of residence duty concession, but this is only able to be accessed by properties of up to $550,000 in value. Now, it's only worth a few thousand, but again, a few thousand is still a worthwhile thing. So it's a concession that reduces your stamp duty by up to $3,100. Another relevant consideration here, talking about those other options with residential parks or retirement villages, possibly granny flat arrangements if you're buying into something where you're not on title, it's your son or daughter's property and you're just gaining those rights. Those are all separate contractual entitlements. They're not transfers of land, therefore they're not subject to stamp duty. So there is a saving to be had there if you're looking at those. If you're looking at those other structures. So in weighing up all of that, we should go through a little bit more detail now on each of those relevant structures, and I will hand over to JY.
Thank you, Josh. So as mentioned, many people may find it difficult to manage a bigger family home, especially after kids have moved out of the property. And when you're deciding to sell your family home, you'll be faced with a crossroad about your next step. And I will take you through the different options and outline some of the important points for you to consider when thinking about your next step. So a popular option for many people when downsizing would be to move into either an apartment in a central location, either in the city or in one of the inner city suburbs, or into a townhouse. One of the main difference between staying in a traditional house and an apartment or a townhouse will be owner's corporation. So what is an owner's corporation? An owner's corporation is basically a legal entity that's made up of all the registered proprietors within the townhouse or apartment complex. And they would normally be, or rather, they would be responsible for the management, maintenance, and administration of the common property of the complex. The role of an owner's corporation would differ greatly depending on whether you choose to move into a multi-lot townhouse complex or within an apartment complex. In a multi-lot townhouse complex, the role of the owner's corporation will be confined to obtaining public liability insurance for the common areas such as the common walkway or driveway. But in an apartment complex, that will be very different. So in an apartment complex, depending on the type of apartment that you choose to purchase, some of these apartments may come with certain facilities such as concierge, swimming pool, jacuzzi, gym, and many more. In these instances, the owner's corporation will normally appoint an owner's corporation manager to manage, maintain, and administer all of these facilities within the apartment complex. However, you will also be required to pay owner's corporation fees, which would usually be collected on a quarterly basis for the administration, maintenance, and management of these facilities. As both this option, the townhouse and the apartment complex option, are often available to the general public, there will not be any form of care facilities available within them, and there wouldn't be any activities that would be organized by the owner's corporation or anything like that. So you'll just be living in your own apartment or townhouse, and you can get to know your neighbors, but there wouldn't be any events that will be available for you to do that. Moving on, the other option for you to consider would be a residential park. Many of you may know it as a lifestyle village. With this option, there is with a residential park, it's basically similar to that of a caravan park, and there has been a fundamental shift in the way that we think about a caravan park, especially in recent years. Caravan parks have traditionally been associated with affordable holiday destination or a temporary form of accommodation. However, many people around Victoria and Australia are finding a caravan park to be a desirable place to call home. Most residential parks will not provide you with any care facilities However, by moving into a residential park, you would have access to many of the facilities on offer and many other group activities with other residents that's staying within the residential parks. So some of these facilities would include a clubhouse, swimming pool, gym, tennis court, sauna, and many more. And some of the activities that would normally be organized by the operators would include mini tours to various wineries or other social events for you to get to know your neighbors or the other residents. We have also seen a steady increase in the number of communal lifestyle offering, and a resident within a residential park would often be an owner-renter, where you will own the home that you live in, but you will rent the land in which your home sits on. So this is a pretty uncommon concept for most in Australia, but this is a pretty common home ownership structure in many parts of the world, especially in places where land is scarce. For example, in Singapore, there are various different structure for purchasing a home, and in some instances, the developer would lease the land from the government for a period of 99 years or sometimes even 999 years, and will sell the property to residents, and this residents will own the home but not the land that their home is actually situated on. However, in this case, or in Singapore's case, these residents will not need to pay any rent for the land, as this would have already been paid for or accounted for by the developer when developing the land. When entering into a residential park, you will commonly be required to sign up on two separate agreements, one for the purchase of your prefabricated home and another for the lease of the site that your home will sit on. Both the home purchase contract and the site agreement are typically dependent on each other for completion, as if you terminate either of these contracts, or if you decide to cool off on either of these contracts, it will not be reasonable for you to then complete the purchase of your prefabricated home, vice versa. Further, as you will only own your home but not the land that your home sits on, there will not be any transfer of title into your name at settlement. In most of these circumstances or instances, when you enter into the home purchase agreement, you will also be purchasing a share of the community infrastructure, which you would then be required to sell back to the operator when you exit or sell your home in future. As a resident within a residential park, there are also various rules and obligations that you have to abide by, such as keeping your home in a clean and safe environment to live in, and you will also be required to abide by any rules that have been established by the residential park operators. There will also be ongoing costs. Some of this ongoing cost would include rent that will be paid either on a weekly, fortnightly, or monthly basis. And further to this, you will also be required to pay for electricity, water, and other sewage or drainage based on your own usage. So in this aspect, this is pretty similar to how you would pay for all of these utilities in your own home right now. So when you exit, when exiting the residential park, you will need to provide written notice to the residential park operators. The time frame for it would normally be advised to you in the site agreement, and you will also be required to either appoint a selling agent, or you can appoint the operator, or you can sell your home on your own. So in this slide, we have an overview of all the costs that will be associated with the exit from a residential park. So normally you would need to pay a administrative fee that would usually be a percentage of the sale price. This would be advised to you in the site agreement. You also need to pay commission to the selling agent. There will be exit fees such as deferred management fees that you will need to pay for, the cost of any repairs or improvement works that needs to be completed by the residential park operators, and any other outstanding rent, fees, and charges that may be payable. So you will be allowed to sell your home at any time. However, you'll be required to provide the operator with prior written notice, as mentioned. When you sell your home, you can sell it to either a incoming resident, or you can potentially sell it to an innocent third party. But in most instances, it would be difficult for you to sell it to an innocent third party because these homes are usually constructed in a way that would not allow it to be transported easily, and the actual transportation cost of this home will be very costly. So it's widely understood that even though it's possible for you to do that, it would not be that simple or easy for you to sell it to a third party and for them to move your home to a separate location. All of the exit fees or deferred management fees are calculated in a way where it's based off the number of years that you have resided in the residential park, and it's normally capped at a certain percentage that will be disclosed to you when you enter the site agreement with the operators. So some people may view the exit fees as something that's similar to that of a retirement village unit when you're selling a retirement village unit. However, there are some that may view the exit fees as something that's harsh and unconscionable. So in a recent VCAT decision in Dowling and Lifestyle Management 2 Pty Ltd, the main issues that were challenged in that particular case was with regards to the exit fees that were payable, as well as rent that was payable even after residents exit from the residential park. So it was argued by the residents that the exit fees that was charged by the operator is inconsistent with the clauses within the Residential Tenancy Act, and that the residents further argued that the payment of rent after they leave the residential park is harsh, especially when they are unable to allow beneficiaries to stay in the residential park, and it is not a straightforward process for residents to sublease their home to another resident. So VCAT found a couple of things. So firstly, Section 206S, subsection 2 of the Residential Tenancy Act requires that all payment amounts such as rent, fees, and charges to be disclosed and capable of accurate calculation at the time that the site agreement has been signed. However, most of these exit fees are often calculated as a percentage of a future resale price, and these are not able to be accurately calculated at the time of signing. So these exit fees are usually based off a future market value and are not able to be accurately calculated at the time that the site agreement is signed, which is why VCAT has declared that the clause requiring residents to pay an exit fees based off a future market value is void. However, VCAT did not prohibit the collection of any exit fees, only exit fees that are contingent on the uncertain resale value. With regards to rent that's payable after they exit from the residential park, VCAT found that it was at least harsh, if not unconscionable, for operators to require residents to continue to pay rent after their exit from the lifestyle apartment. The VCAT member also observed that there should be some fairness around the occupancy or subletting of the lifestyle apartment, with consent from operators not to be unreasonably withheld. Following this case, it's interesting to note that lifestyle communities have announced that it will cease the charging of rent to deceased estates. So this is an important case within the residential park sphere, as it provides some form of certainty to the current and incoming residents of their protection regarding the fees payable when they exit the residential parks, as well as rent that may be payable by their estate. It is also an important case for operators of residential park to ensure that these contracts that they have signed with residents are compliant with the relevant legislation. And we strongly recommend incoming residents to have their agreements or contract reviewed by our team in order for you to further understand your rights and obligations prior to entering them. And for any operators out there, feel free to reach out to us to ensure that your contracts remain relevant and compliant with the relevant legislation. So moving on to retirement village. I'm pretty sure retirement village as an option when downsizing from your family home is something that's very familiar to all of us. If it's not familiar, you would have heard of it before. So most, or rather, all of these retirement villages are governed by the Retirement Villages Act 1986, and residents within a retirement village would be 55 years or older, or are retired from full-time employment. So residents in a retirement village will receive certain types of services, such as having a doctor or a nurse visit, meal services, organized outings, and a lot more, depending on the type of village that you're in and the services that the village that you're in provides. So there are many different types of structure or contracts that's used by retirement village operators. The main difference between them, as we see it, is whether or not you are a registered proprietor. So most of these retirement village operators are moving away from the registered proprietor structure and into a loan and lease or loan and license agreement, or sometimes even the purchase of company shares or unit trust structure. So I'll take you through each of this structure and explain it a little bit more to you, starting with registered proprietor. So as the registered proprietor of the retirement village unit, you will be recorded on title as the registered proprietor when you purchase this particular retirement village, same as you would when you purchase any other properties in Australia. And you will sign off a normal contract of sale and vendor statement as you would when you're purchasing any other property. However, you will also be required to enter into a management contract with the retirement village operator, which would detail the rules and regulations of the retirement village and will address the amounts that are payable when entering into the retirement village, ongoing fees that's payable, as well as your exit entitlements. The retirement village operator will also be registering a retirement village notice on title, and this would act to prevent you from transacting with the property without the retirement village's knowledge. This is to ensure that anyone that transacts with a retirement village will still be regulated by the retirement village operator and receive the protection of the Retirement Villages Act. So the next structure that is a very common structure that we are seeing nowadays is a loan and lease or loan and license. So what does this structure do? So basically, this is a structure where you enter into a lease or license agreement with the retirement village operators from the provision of services, for the provision of services, and there will also be a separate contract for the payment of the ingoing contribution, often known as the loan, and what happens to this loan amount or ingoing contribution when you exit the retirement village unit. So moving on to company shares or unit trust. So this is a slightly more unusual structure whereby you purchase shares within a company or within a unit trust, which then entitles you to the occupation of the property or the retirement village unit. So apart from the purchase of shares or purchase of units agreement, you will also be required to enter into a management contract with the retirement village operator for the provision of services. So when you exit the retirement village, you will also be required to sell the company shares or company or units back to the unit trust or company, or to the incoming resident. So in all of this structure, the common denominator to all of them is that you will be required to enter into a management contract with the retirement village operator, and this particular management contract would basically govern the fees and charges that will be payable throughout your stay in the retirement village unit, the rules and regulations around this staying or rather your conduct in the retirement village unit, as well as the fees and charges that will be payable upon your exit from the retirement village unit. So I'll take you through the whole process from the signing of the management contract all the way to when we sell it. So in accordance with the legislation, the retirement village operators are required to provide you with all of the necessary contracts and disclosure statements at least 21 days prior to you signing off on the documents. And after you sign off on the documents, you would have a further 3 clear business days to exercise your cooling off rights. So you will have a relatively long time to properly consider whether or not entering into a retirement village would be the right option for you. So this is a purposeful thing that is listed in the Retirement Villages Act to ensure that it's a big step for anyone moving into a retirement village, and it's to provide you with sufficient time to properly consider your options and making sure that this is the right move for you. So one important thing to note is that if you will be a registered proprietor of a retirement village unit, you will need to ensure that the contract of sale that you're signing for the purchase of the unit would be subject to the execution of the management contract. Because if you were to exit out of either one, without it being subject to the execution of the management contract, it will be a slightly harder process for you to exit out of the contract of sale. So moving on to the rules and regulations. So some of the general and important rules that you should note, noting that every retirement village may have a slightly different set of rules or variation of the rules. You will be required to maintain your apartment in a good and tenantable condition. It is also normal for retirement village operators to install some form of emergency call system within the apartment for you to activate in case of an emergency. Accordingly, you will also be required to grant the retirement village operators access to your apartment in case of an emergency. If you do wish to make any alteration to the apartment, you will also be required to obtain prior consent from the operators, and in most instances, you will be responsible for repairs and replacements of items within your apartment apart from fixtures, and the operators will be responsible for repairs of a structural nature. And the repair of and replacement of fixture not arising from your misuse. Should you exit out of the property due to you requiring higher care, in most instances, it is important to note that 2 doctors would need to sign off on this particular decision. 1 doctor can be appointed by you and the other appointed by the retirement village. This is to ensure that the decision for you to exit out of the retirement village unit is fair. Should you have any guests or invitees that's coming over, you will also be responsible for their action, and you must also ensure that all your guests and invitees comply with the rules and regulations set out by the retirement village operators. You are also not allowed to transfer your rights to someone else without the prior consent of the retirement village operator. So with regards to ingoing and ongoing fees and charges, so ingoing contribution is just the entry cost, and it will depend. It generally depends on how nice of a retirement village unit you're getting or how big it is, and the sort of services that you'll be provided. So the entry or ingoing contribution would vary that way. With regards to ongoing costs, you will normally be liable for payment of a monthly service charge to the operators, and that's for the services that they've provided to you. This particular monthly charge is payable dependent on the level of services that you receive, and other ongoing fees that you'll be payable for, such as additional costs for contents insurance, council rates, water, and utilities as per your own usage. In most instances, the operators would maintain an insurance for the replacement of the building and any other improvements, but you will be required to have your own contents insurance for your own personal possession. If you are a registered proprietor of the retirement village unit, you will also be required to pay an owner's corporation fee that will be levied either monthly or quarterly. So when exiting out of the retirement village, you will be responsible to pay a departure fee that would normally be calculated as a percentage of your ingoing contribution. Departure fees are commonly known as deferred management fee, and that's usually capped at about 20 to 30% of your ingoing contribution. Each operator may have a slightly different way of calculating the deferred management fee, so do check out the contract that you sign when you enter into the retirement village. So you will also be required to complete either a reinstatement or refurbishment of the property when you exit the property. Depending on the state of the property, you will either be recommended to complete a reinstatement or refurbishment of the unit. You will also be required to pay the reinstatement or refurbishment cost for the property, restoring the property back to its original condition. And this is to ensure that the ingoing contribution paid by the incoming resident will be fair and reasonable. So you will also be required to pay for the operator's legal costs and other sale costs, such as advertising and sale agent fees, when exiting the retirement village unit. And in most instances, you will also be required to pay a service charge until the earlier of either settlement, releasing the property, or 6 months after departure. So depending on the arrangement, you will either share or be entitled to any capital gains on your apartment, or you will not be entitled to any capital gains. So this will be the same for any capital losses suffered, and this will all be set out in the initial documents that will be provided to you, and we will be able to review them and provide you with further advice when it comes to it. With regards to the deferred management fee or departure fee, we are seeing some interesting structures out there. So recently we have seen some whereby instead of paying an ingoing contribution on entry, you would pay two lump sums. So one for the ingoing contribution and another lump sum known as an establishment fee. And with this particular structure, it removes your entitlement to any capital gains or losses, but it also removes any reinstatement or refurbishment costs that is payable by you on exit. And this establishment fee will replace the deferred management fee. However, one important thing to note is that this particular option is rarely offered by operators. And this is something that's interesting to note. But with this particular, the advantageous point for this particular structure is that it provides you or your beneficiaries with a lot more certainty about the amount of money, or rather the exit entitlements that you will receive at the end of the day. So the other option after retirement village would be entry into an aged care facility. So if you do require some form of care to be provided to you, you may also consider an aged care facility. An aged care facility will provide you with long-term and ongoing care. You will also be provided with various accommodation options, access to medical care, and other assistance, including help with day-to-day activities. So in some instances where the retirement village operators have some ties to an aged care facility, you may be given priority to enter the aged care facility. However, in other instances, you will be responsible for securing and transferring into an aged care facility on your own. Given that this would usually be completed within a short time frame, and you will not necessarily have access to your full exit entitlements, the retirement village operators will be responsible to provide for your aged care refundable accommodation deposit or daily accommodation payment, RED, commonly known as RED or DEP, whilst you're not yet entitled to your exit entitlements. That's all for me. If there are any questions, you can pop them into the chat and we will answer them.
Thanks very much, JY and Andre. We do have a minute or two for questions if anyone would like to. I can see a couple of good questions have come through which Andre's answered. So if you want to look at those in the Q&A box, you can. Do you want to comment any further on those, Andre?
Yeah, I might just maybe run through. I'll deal with the second one first. I think that's helpful for everyone. With retirement village contracts, if you've got, say, two people that live in a particular unit or apartment, but only one of them has signed the agreement, it's important to understand that only the person that signed the agreement is actually the resident from the village's perspective. So the other person doesn't have any greater right or entitlement. And actually, a lot of village agreements have restrictions on anyone else living at the actual apartment, where they'll say that a third party, whether it's partner, friend, son, daughter, they would only be able to live there for, say, 7 days continuous, 14 days continuous, unless you have the village's express consent. So what people will commonly do is obtain that express consent either on entry into the village. There might be a reason why you're wanting to enter into the agreement in only one name, perhaps only one of a couple are funding it, and there might be estate planning reasons why you might want to control the flow of the proceeds of any sale of the village unit or apartment. But if you want the other person to live there, you're going to want to have that documented. The village has to expressly consent to it. A lot of times that consent will come with a couple of strings in terms of the other person signing off on their own short agreement or acknowledgement that they don't have any greater interest in the property or in the funds that have gone in to fund it, and that they will have a limitation if the main resident who signed the agreement decides to leave or passes away or has to go into care. There's going to be those active limitations there. I think we've had another. Oh, that's Craig. Yeah, so that's your question, Craig. And then the other question was about residential parks. Since you're only leasing the site and obviously you're owning the building, can the owner kick you out, not renew the lease, etc.? Now, for these residential site agreements, the important part there is to note that they're not usual sort of 1 or 2 year type residential tenancy agreements. The site agreements are, as JY has said, usually for a number of years. A 49-year agreement, 99-year agreement is not unusual. Usually it's a little bit reflective of the residents that are there, so perhaps closer to 49 than 99. But that being said, the renewal side of things probably won't come into play. In terms of broader abilities to kick you out, they certainly exist, both in the contracts and in the residential tenancies legislation. If there's non-payment of the ongoing rent, if there are behavioural issues that affect the operation of the site, those things will certainly give the owner an ability to kick you out, but there are processes in place, limitations and notice periods that will apply. So it's not done lightly, and because you're able to access it from a resident's perspective, because you're able to access remedies and disputes through VCAT, they're actually things that can be fought against if something untoward is happening and you want to defend your rights there. You do own that building ultimately that's sitting on the site, and as JY has said, although it is technically possible to extract the building and sell it, it's often physically very difficult in terms of the nature of the homes that are built in these lifestyle communities. In terms of reletting the site and the house to someone else, given you own the physical house, again, that's physically possible now. That recent lifestyle villages case has helped with that. It is common to have restrictions in the actual contracts to prevent that kind of reletting. Ultimately, that impacts the business model of the operators. But at this point in time, that is essentially a requirement where the villagers have to not withhold consent unreasonably for that reletting to occur within deceased estate context or similar. JY, I don't know if you want to comment further on that aspect of things.
I think covered it all.
Okay, excellent. So yeah, if anyone else has any other questions, we're happy to answer them off the chat. Feel free to contact us. I think as we hit high noon, I'll hand back to Mitch.
Thanks, Andre, and thanks, JY. Lots of useful information there, and I'll just quickly skip through to the contact details again. Just a reminder, this webinar, as with all our other previous ones, will be on the resources page on our website. And do follow us on social media to find out when that is up, and also other articles published by the team from time to time. I've got an upcoming webinar in a couple of next few weeks, next month. But yeah, here are the details again for Andre and JY. Again, you can find that on the website. So we'll leave things there right on the hour. So thank you very much, everybody, for attending. We hope that's been useful, and enjoy the rest of your day. Thank you.